They're simply trying to find one. They're demanding records. They're abusing the grand jury process, digging through years and years of random documents. Donald Trump isn't just coming after me because of my mean tweets. He's coming after me because I'm considering running for president.
Ladies and gentlemen, just 3 weeks ago, California Governor Gavin Newsom stood before the cameras with a message of open defiance. He accused President Donald Trump of weaponizing the Department of Justice, claiming the federal government was being used as a political instrument to destroy one of Trump's most prominent potential rivals. Newsom insisted federal investigators had found no evidence that he had committed any crime. According to him, prosecutors were simply searching for an excuse, any excuse to bring criminal charges against him. He declared that he had nothing to hide and welcomed any investigation.
We're going to help the people in California. We want to have no crime. I know Gavin was here. I used to get along so great with Gavin when I was president. Gavin's a good guy.
But this morning, the entire landscape may have changed, because in every federal criminal investigation in the United States, there is one principle every experienced defense attorney understands. As long as investigators are relying primarily on documents, financial records, and circumstantial evidence, the subject of the investigation still has room to explain, reinterpret, or challenge the government's case. Everything changes when someone from the inside begins cooperating with the FBI, especially someone who once belonged to the governor's innermost political circle. According to newly reported information, one of Gavin Newsom's closest political associates allegedly spent an extended period secretly cooperating with federal investigators, reportedly wearing a concealed recording device during private meetings over the course of months, or possibly even longer. If those reports are ultimately confirmed through official investigative records, this would no longer be a case built primarily on financial documents or witness testimony. Instead, it could become a prosecution supported by direct evidence collected from someone who worked side by side with the very people now under federal scrutiny. For any federal prosecutor, that is often the turning point. History shows that major federal corruption cases rarely begin with newspaper headlines, campaign speeches, or partisan accusations. They are typically built piece by piece from insider testimony, recorded conversations, internal communications, financial records, and evidence establishing not only what happened, but who knew about it, when they knew it, and what role each individual allegedly played. If the FBI is, in fact, in possession of legally obtained recordings documenting conversations between Governor Newsom and members of his inner circle, and if those recordings were to show evidence suggesting prior knowledge of, direction of, or participation in violations of federal law, the governor's legal exposure could increase dramatically. At that point, this would no longer be a political fight between Republicans and Democrats. It would become a question of evidence. The timing is equally significant. These developments come after Dana Williamson, Newsom's former chief of staff, entered guilty pleas in federal court. According to court records, Williamson admitted guilt to conspiracy involving bank fraud and wire fraud, filing false tax returns, and making false statements to federal agents. To be clear, the guilty plea of a senior aide does not automatically establish criminal liability for Governor Newsom, but for federal prosecutors, it often marks the beginning of a much larger inquiry. Was the misconduct the work of one individual acting alone? Or was it part of a broader pattern directed, approved, or knowingly tolerated by higher-ranking officials? At the same time, publicly available information has drawn additional scrutiny to a nonprofit organization run by Jennifer Newsom. The organization reportedly received significant financial support from political donors connected to Governor Newsom. Payments made to Jennifer Newsom, along with financial transactions involving her for-profit production company, have raised questions among investigators and political observers alike. Those transactions, standing alone, do not establish criminal wrongdoing. However, if investigators were to determine that nonprofit funds were diverted for unauthorized purposes, used to conceal the true nature of financial transactions, or handled in violation of federal tax laws or nonprofit regulations, those activities could become part of a broader federal investigation. And now comes what may be the most consequential revelation yet. Alexis Podesta, a longtime political ally of Governor Newsom, is reportedly believed to have begun cooperating with the FBI as early as mid-2024. If that report proves accurate, the significance lies not in the recording device itself. It lies in what that device may have captured. Inside a federal courtroom, legally obtained statements made by defendants or their closest associates often carry far greater evidentiary weight than political rhetoric, campaign speeches, or television interviews. If those recordings, combined with cooperating witness testimony and financial documentation, form a consistent chain of evidence, Gavin Newsom's political future could face its greatest crisis to date. His ambitions for a 2028 presidential campaign could be severely damaged. And if federal prosecutors ultimately conclude that sufficient evidence exists and a federal grand jury returns an indictment, Governor Newsom could find himself facing the same federal criminal process as any other American citizen. If that day comes, the central question will no longer be whether Gavin Newsom can survive politically. The question will be whether he can successfully defend himself against a federal criminal indictment. Under U.S. law, federal investigators cannot simply decide to employ electronic surveillance because they suspect wrongdoing. They must first convince a court that there is probable cause to believe a federal crime may have been committed and demonstrate that conventional investigative techniques have proven insufficient or are unlikely to succeed. The application then undergoes review within the Department of Justice before a federal judge can authorize the surveillance. Each authorization is valid only for a limited period, and every extension requires renewed judicial approval. In other words, if the timeline described by the program is accurate, the use of this extraordinary investigative tool would have passed through multiple layers of legal scrutiny, not simply the product of political motivation or prosecutorial discretion. Later in the interview, Cliff Maloney offered an observation that deserves attention. He emphasized that he does not believe every rumor is true. However, in his view, when a trusted insider agrees to cooperate with the FBI and secretly record conversations over an extended period, it usually suggests that investigators believe they are pursuing a case with substantial factual support. That, however, is Mr. Maloney's personal assessment, not an official finding by law enforcement. From a prosecutor's perspective, however, the more important question is a different one. What causes someone who once stood among a politician's closest allies to become a cooperating witness? In federal criminal practice, cooperating witnesses often choose that path in hopes of receiving leniency or negotiating a plea agreement with prosecutors. In this case, however, there has been no official confirmation regarding Alexis Podesta's motives, and any explanation for her reported cooperation remains speculative. If prosecutors were eventually to confirm that she entered into a formal cooperation agreement, her testimony would still need to be corroborated by financial records, electronic communications, documentary evidence, and other independent sources before it could serve as the foundation for a federal indictment. Maloney also raised a broader political question. According to him, Gavin Newsom moved quickly to frame the investigation as a politically motivated witch hunt, arguing that he had become a target because he was widely viewed as a potential Democratic contender for the 2028 presidential election. But if the investigation had, in fact, been underway for months before those public statements, as the program's reporting suggests, federal prosecutors would likely be asking a very different set of questions. What did Governor Newsom know about the scope of the investigation when he made those statements? Did he already know that individuals within his own political circle were reportedly cooperating with the FBI? And did his public comments accurately reflect what he knew at that time? Those are questions that cannot be answered by political arguments. They can only be answered by evidence. Perhaps Maloney's most striking observation came at the very end. He argued that what Gavin Newsom may fear most today is not the headlines appearing in the media. It is the conversations that took place behind closed doors. Which meetings may have been recorded? Which phone calls may have been captured? Who else was in the room? If those recordings truly exist, and if they contain evidence that prosecutors believe demonstrates violations of federal law, they could become a powerful foundation upon which a federal indictment is built. Throughout the history of federal public corruption cases in the United States, more than one political career has collapsed not because of a televised debate or a press conference, but because of a recording lasting only a few minutes. And if this investigation continues to develop along the trajectory that many legal observers are watching closely, Gavin Newsom's greatest challenge may no longer be defending his political image before the voters. It may be defending himself before the federal justice system.